Alex, thanks so much for joining me today, and welcome back to New Mexico in Focus.
Thanks for having me.
Okay. I would like to start with a phrase that I have heard entirely too many times in the course of doing journalism for 20 years. The phrase is, we can neither confirm nor deny the existence of an investigation. So that's sort of the default setting for the U.S. Attorney's Office. Why is that?
There's a number of equities that we protect, in justice. So we are entrusted as prosecutors, but especially in Department of Justice prosecutors, with this huge power, right? Even to know that you're being accused or somebody's being accused of a crime, right? It has a huge impact on their life, the people around them. And so in protecting the rights of people, we have to always balance a number of things when we approach any case, right? And so this answer you've doubtless received, and years of speaking with us about either investigations you suspect are ongoing, or cases even that might be pending, yet we're not going to give you anything on it until it's sentenced. And so we protect a number of equities here in the Department of Justice. The first, of course, is a person's rights to a fair trial, right? So if we start getting out in public and talking about things that we haven't proven in court, then that person's jury pool is hearing these things. It not only makes it more difficult for us to pick the jury in the first place, but it makes it more difficult for a person to have a fair jury, right? Someone who's going to hear the facts for the first time from the parties in a situation where a judge is overseeing and determining what is legal to come in and what is not. So we want untainted juries. The second part is people's rights to privacy, right? So if you're the target of a federal investigation, I'm not going to tell other people because that could affect your job, it could affect your marriage, it could affect your friends. And so this is a thing that, if released publicly, has a huge and deleterious impact on your life, right, as a defendant. And then, of course, we balance these against a couple other interests, including our rights, our interest, our job, which is charged with public safety. So we have to balance the safety of the public, the needs of the public in securing their safety against whatever crime or allegation it is. And finally, there's the interest that you protect here, which is the interest of the public to know broadly what their Justice Department is doing, know that we are doing the job and not sleep at the wheel, and know that it's functioning correctly. And so we have these 4 areas that we have to protect in every single case. The clearest line that we've found to draw here is the one of indictment, right? So when we have taken it to a grand jury, or we have taken a complaint to a judge, and that person or that grand jury has said, we are finding by probable cause that these offenses happened. That stopgap has been crossed in the system, and we are formally accusing people of a thing, right? We take our responsibilities in advance of this charging decision very, very seriously. There's a lot that we do in advance of charges being brought against someone because we know the impact it has on people's lives. But even then, you'll see in our press releases and in our discussions, in our answering of questions, even after charging, we hew very closely to just the things that we have said in courts and on the record. Because when we say things in courts and on the record, we are responsible. We are held to account for the veracity of those statements in front of a judge. The same can't be said to be true about statements in public, from public officials, from politicians, from law enforcement, but it can be said to be true when we're offering testimony in court, when we're offering evidence in court, when a court has deemed it admissible. And so for that reason, even then, after we've charged somebody, we are still very cautious about commenting on a case until finally we've convicted, we've sentenced, and that's when we give our press conference, that's when we do interviews, and that's when the public gets to know a whole lot more about what happened than from the initial indictment or complaint.
I appreciate the explanation. I think that there's a possibility that the next time I receive that response from your office, I will be a tiny bit less irritated. Does that policy, does that present any challenges for you as a federal prosecutor?
Sure, it does. We're balancing these things, right? And so the fact that we want to protect a person's right to a jury, want to protect their privacy, doesn't erase the fact that we know the public needs to be protected, first and foremost, and they need to be informed about what we are doing, that we are doing it, that they can trust that we're doing it, and that it'll come to a just result. And so it's a constant balance.
Gotcha. So in this particular case, this ongoing investigation into possible misconduct by Albuquerque police officers and others, you decided to go a slightly different route. You wrote letters to the district attorney and to the police chief in which you did confirm the existence of this investigation. I'd love to have a little behind the scenes on what led you to make that decision. What sort of factors went into sort of detouring from the usual policy?
Sure. As with any policy, our policy on discussing cases has exceptions, right? This is how lawyers operate within the realm of exceptions. And so there's a couple that apply to us when we're dealing with cases of this, this amount of interest from the public or interest to the public. The U.S. attorney in any given district or the assistant attorney general at the Main Justice have the ability to find exceptions. So they can look at it, they can look at a case or an investigation and say, there are reasons why we should confirm that federal law enforcement is doing their job here. Or there are reasons why we should release information that have to do with protecting public safety. And so in a case, for example, where people see a bunch of folks wearing FBI and bright yellow on the back of their jackets go into a house, but there is no other explanation for why or when or how, there is often a public interest in knowing this is actually law enforcement. They're actually authorized to do this, and this is part of something that is happening, and we can trust that there is a process here, and not just rogue people who bought jackets, at Spirit. And so, when we discuss cases, and this one with the investigation you're referring to, we confirmed early on federal law enforcement activity at various locations, as we were asked by the public. Because we felt that it met that requirement, it met that need, which is people are seeing federal law enforcement activity happen, and they don't know what is happening. And so for us, that small bit of confirmation allows us to tell the public, don't worry, this is authorized, we put thought into it, and we are working on it.
Sort of an authenticity stamp, if you will.
Yeah.
I want to talk about a word that you used in those two letters I just referenced to the DA and the chief. You nodded toward the tension between the public's understandable desire for information about something like this and the secrecy needs that you just sort of described. Let's pull out a little bit from this investigation and talk broadly, how do you balance those two principles? What goes into that?
A lot goes into it. Everything that we do in our job is a careful balance of the various needs that we protect. It's really unique being, especially a federal prosecutor, but being a prosecutor. Amongst all lawyers, our job is very different. It's distinct in that most lawyers, they take a case or a client, and that is the interest that they represent, right? They're being hired to exercise that person's interests at the expense of all others. That is never ours. And so in everything that we do, we are thinking about all of our clients. For the Department of Justice, that is the United States, right? And for us, what that means when we walk into a courtroom, the equities that we protect are not the government's, as often courts like to refer to us. The equities include not just the people on the streets and the members of the community, but the jurors themselves, the defendant himself, his attorney, the judge. All of their interests as members of our community are balanced together. And so as a federal prosecutor, we deal daily with the balance between different interests for different people, what is best for the community and public knowledge versus what is best for an investigation, and most importantly, what protects the rights of the target or defendant as well, right? Because until the person's accused publicly, the person is considered innocent, right? They should walk free from any public aspersions over what they may or may not have done. And so when we do our job, we try very, very hard to maintain that protection, not just of the public and the safety concerns, but of defendants too, and their interest in privacy, their interest in walking free until a grand jury or a judge has said there's probable cause to say you did this thing.
And of course, the innocence presumption still attaches at that point, even after indictment.
Absolutely.
So it's been 7 weeks now since what you just mentioned a moment ago, since y'all kicked some doors in and executed some search warrants. I think it's important for people to hear you say, what can you tell us about this investigation at this stage in the proceedings? What's the full extent of what you can say?
Well, Jeff, I can't confirm or deny the existence. No, so we have obviously confirmed that an investigation is underway. We've confirmed locations in response to public and media inquiries where federal law enforcement action occurred. And from the letters that we issued to both the district attorney and the chief of police, we've confirmed that they knew about the investigation, but were not read into its full extent, right? And that's because when we are protecting an ongoing high-level investigation, there are often partners who we work with, but we don't share everything with. And so, as you identified, we're going to let them know as much as we can for them to fulfill their own duties. So, in our letter to the district attorney, we acknowledge that every prosecutor has a responsibility, a constitutional one, under Brady and Giglio, to protect the process by identifying certain we call Giglio conduct. And so, when we run up against these other responsibilities, we share what justice demands. But on the other side of it, we keep as much in-house as we can until we're ready to level an indictment.
So for people who don't know what Giglio material is, that we're essentially talking about information that could impact a witness's credibility in court, right?
That's correct.
Okay.
There's a broader constitutional protection called Brady, so exculpatory information, a subset of what Brady, and so the constitutional requirement for Brady is obviously that if we have something that says the person we were thinking did something did not do it, then we have to disclose that evidence. A subset of that is Giglio, as you identified, which is if we have information that can be used to cross-examine or impugn the credibility of one of our witnesses, we should disclose that too. And so when we run up into these either constitutional requirements or protections, again, we protect the defendant too. And so that's where we work with the DA. This is where we were sort of working in a similar but alternate track with the chief of police. But again, the letters show that while they were aware of investigations, they are not aware of the full scope.
Gotcha. I want to ask another question sort of related to balancing. Mm-hmm. The law enforcement community in New Mexico is relatively small, relatively tight-knit. Obviously, your office and the FBI conduct joint operations with APD, the county sheriff's office, and the district attorney's office all the time. Mm-hmm. How would you respond to public concerns about the possibility of one of your investigations being contaminated or compromised because of these relationships that can develop?
Yeah, there's always a concern that information can leak. As a law enforcement investigator, there's always a concern that information can leak before you want it to. This is why for step one, we work in sort of insulated circles. When we're working with cases, we deconflict, it's called, which makes sure no other law enforcement is working a similar case against a similar person. But we also wall off, right, as is identified in these letters sent to the DA and the chief, non-essential law enforcement components from what we are doing. And so while there is always a worry that things could be leaked, we also operate in a world where we have to trust each other to move forward, mm-hmm. right? And so amongst federal law enforcement, it is a very tight-knit community here. We work all the time and constantly, and also with our local partners, to face the many challenges we have here in New Mexico. And so it's a tight rope to walk, but you have to understand you got to take some risks if you want to get the right cases and the right people. And so we balance those risks. We manage and mitigate possibility of disclosure before we want a thing to be disclosed. And we trust. We rely on each other day in and day out. Our federal law enforcement partners, put their lives in each other's hands. And so it's with this trust that we go forward on these kind of investigations.
There is a little bit of a needle to thread in a case like this. Obviously, the nature of the federal inquiry here is criminal. It's a criminal investigation whose stakes, of course, are someone's freedom at the end of the day. On a parallel track, you've got an administrative investigation that the police department itself is conducting, the consequences of which could be someone's job. Mm-hmm. For example, when a police officer is interviewed in an internal affairs investigation, he's read what's called a Garrity warning, which essentially is him saying, I'm giving up my Fifth Amendment rights here. I'm going to talk to you and answer your questions. You wouldn't be able to use any of that in your criminal proceeding. How do you make sure, broadly speaking, again, not just in this investigation, how do you make sure those two things stay separate?
Sure. And so we have a lot of, we invest a lot into protecting our investigations, both from being leaked or public knowledge, but also legally, right? So like it's our job to both present the case and win it. And so if we present a case but there are constitutional problems with it, we have not done our job, which means and there are many stopgaps that we put in place to ensure that we are advancing a legally defensible case. In some cases, that'll mean we have filter teams who are entirely a separate team of both agents and AUSAs. A filter team works in a situation where there might be something that the prosecuting team shouldn't have, right? And so we will often use filter teams to take a first read of whatever it is that we're looking at, and the filter team can then pass on non-tainted evidence to the prosecution team to go forward with. And so it's by essentially doubling the resources we invest in any case, but we do it again to protect the integrity of that case and its presentation to the jury.
I want to completely shift gears and talk about the consent decree for just a moment. The message to the public from your office, from the city of Albuquerque, has been that we are this close to ending a decade of federal oversight for the Albuquerque Police Department. There's been quite a bit of speculation in the vacuum of silence since news of this investigation broke about whether this could impact the consent decree. Of course, one of the things the Justice Department found when they looked into APD was a total lack of internal controls. The Internal Affairs Division was not functioning. They couldn't police themselves. We are now reading stories in the newspaper that you've got a couple of internal affairs supervisors on leave now in connection with this investigation. My first question is this. When I read that 8th section of the consent decree that talks about complaint intake, complaint investigation, it seems to me that it is not directly just connected to use of force. Do I have that right?
I think you're right. I wasn't involved in the original charging or investigation, the consent agreement, but my read of it is that it went far beyond, in a good and aspirational way, the actual investigation and findings during the investigation of the Albuquerque Police Department. In doing so, the Albuquerque Police Department, Albuquerque City, crafted this really, truly aspirational consent agreements that they hoped that their department would live up to. It involved many things that weren't included in the initial investigation or findings. But I do think, I will say, and I don't know what's going to happen in court. I don't know, what the parties are going to move for. I don't know what the court is going to find. But I do think that for any police department, especially ours, a functioning internal affairs department is critical to the administration of that department. And so I would guess that a functioning internal affairs department is what the city will receive after this investigation plays out.
Is your office reviewing, how to ask this, is your office reviewing anything in connection with this investigation that could impact the conclusion of the consent decree?
I don't think I can speak to that.
Okay. Okay. Moving away from the impact that this might have on the consent decree, in high-profile investigations like this one, who makes the ultimate decision on whether to charge?
Sure. It depends. Most decisions, most criminal charging decisions, in fact, all criminal charging decisions are approved by the United States Attorney for any given district. And every single criminal indictment, and we issue many every week, every month, we hold a screening committee where all of our management and myself read every single indictment, every single prosecution memorandum, which details a case, its elements, its the facts and witnesses, weaknesses, and constitutionality. And in doing that, we approve or we don't every single criminal indictment that comes in this district. For vast majority of cases, the final authority lies with me. There are some exceptions, though, and exceptions are what we do as lawyers. Throughout the Justice Manual, which is a document that has been created over the years for procedures for federal prosecutors and Department of Justice prosecutors to follow, it outlines there are several carve-outs there for where responsibility could lie. In certain areas that are a little bit more, that may have more national interest, areas that might have, that may be a specifically tricky statute. There are other authorities that go to Main Justice and the criminal division up there for them to have a say or the final say. This happens both in the criminal and civil side. Sometimes I'll have authority, sometimes the authority will be vested up there, and of course, the final authority is always the boss, the Attorney General.
Right.
But there are some cases, I'll give you an example of when we use RICO or Vicar type criminal charges. There are some cases there where we have to go actually to main justice, go to the criminal division, consult with them and get approval on using those charges here in the state. And so the answer is sometimes it's here, most of the time it's here. Sometimes there's authorities in Washington, D.C.
Gotcha. I have seen a number of federal investigations of local law enforcement in the decades that I have been doing this, and I've seen examples of cases where I was able to confirm that an investigation did exist. It did not end in an indictment. There were no handcuffs. There were no perp walks. But nothing was ever said again about the conclusion of a couple of those investigations. I'm thinking specifically about allegations that officers were tampering with body camera video and shootings. I know there were investigations, but there was never any sort of an announcement at the end that the investigation had concluded. Mm-hmm. You and I spoke some before we sat down today about an op-ed that Preet Bharara, the former U.S. Attorney for the Southern District of New York, wrote, sort of pushing for a little bit more transparency on the back end of investigations that don't end in indictment or charges. I'm curious how that op-ed struck you and whether there is a conversation among U.S. attorneys in this country to maybe provide a little bit more closure at the end of these.
Sure. And there's initially a distinction I want to draw at the top, which is there's a difference, I think, between, and it gets a little conflated in this discussion, notice to the public, right, and notice to a potential target, right? And so I think, Preet in his op-ed talks a little bit about the anxiety that a potential target might be feeling. But I think that is a separate equity than that of the public in knowing whether or not something's happening or not happening, right? And so I think in thinking about, our practice here, I don't have, and I probably should have run some numbers, but in my experience, this plays out in a couple different ways. And the first thing that came to my mind was this: we have a special responsibility here when we serve Indian country, right? And so we have 22 tribes and pueblos here in the state of New Mexico. We have a special trust responsibility as the federal government to them. And as a component of that, we issue declination letters, which is a letter that's saying we've reviewed the case and we are not charging. Right? This gives finality to the tribe to whom we issue these notices about what has happened with the case or not happened. So it serves some of those equities in a very direct but unique way for in New Mexico and those who serve tribal territories. And looking through the Justice Manual that I referred to earlier, there's a couple different areas where that discuss whether or not we talk about a decision not to go forward against a target with the target themselves. And I think, again, this will highlight the equities I discussed at the beginning. So in some criminal and civil rights investigations, we are actually encouraged to give the public notice about what has happened. And the equity that protected there, of course, is the public's interest, because, especially in the case of police officers that are specifically identified, or law enforcement officers. And the reason there, right, is to step back, is the trust of the public in their institutions, that the people policing their streets and who are supposed to keep them safe are doing their job and doing it constitutionally. And so the Justice Manual and generations of U.S. attorneys have identified the need in those cases specifically for us to interface with the public about it. There's another section that gives us the authorization to do so. I think Preet may have referred to it obliquely in his piece. And it says that we have the discretion, we U.S. attorneys, have the discretion to let a target know that they are no longer a target. And it gives a couple steps of analysis. I think the first one, obviously, is a case where the person being investigated knows they're being investigated. Yeah. Right? There's no world in which we're going to go out and knock on someone's door and be like, hey, we investigated you for 2 years, but you're good. Right? And so the person has to know they're being investigated. And second, we have to know that we are discontinuing the investigation of them without an indictment or charge, or that they're being exonerated. And so we've discovered evidence that says that they are not guilty or they're innocent of the crime. And so looking at these circumstances, And I'll throw in one final caveat before I talk about it a little bit. So the final caveat is this. As federal prosecutors, we're distinct from state prosecutors, right? We're distinct from the state law enforcement system. A state prosecutor, a district attorney, they have the responsibility to charge the crimes in their jurisdiction. There's nobody else charging the crimes, right? Every crime that we charge as federal prosecutors, as outlined by the Justice Manual, is a policy decision, right? Every time we bring in indictments, a criminal charge, we of course begin saying, did a crime occur? Was it constitutional? Can we prove this to a jury beyond a reasonable doubt? Those are our baselines. But after that, the analysis we do in every single case is as a policy matter. Is this best charged federally? Which means, are there other alternatives to criminal charging? Are there other jurisdictions who could handle this? Is there a substantial federal interest in doing what we are doing? So not bringing a federal indictment isn't necessarily a clearing of a person's name. And I think finally, and most interestingly for me, is, Preet puts in this, he acknowledges, right, an exception that I feel almost eats the rule here, which is we can always say in a letter exonerating somebody, saying, we are not going forward on this investigation that is happening of you, but we could always go forward later. And so that, while I understand it, right, and while it's persuasive to me that people want finality, I don't know that this letter is proposed saying we're not doing it now, but we could do it any other time up into the statute of limitations, which is going to run in any case, right? I don't know that that solves the problem.
Interesting. My last question is this. Should folks here expect some public closure in this case, regardless of its outcome?
Folks should expect public closure.
Alex, thanks so much for coming down today. I really appreciate the chat.
Thank you. No, I appreciate it.